Now friends, now we are going to talk about a Spacial court. It's a concept which is gaining the ground. Very important. Important from the examination point of view. Important otherwise. And it's a new concept. The whole idea about the Spacial court is speedy trial. And the Spacial court is virtually in the position of session court. As we have the session court, the position of the Spacial court is equal to session court. It works under the jurisdiction of the High Court, within whose jurisdiction the Spacial court is established. Now friend, let us see. Section 435 of the Companies Act 2013 talks about the Spacial court. Who constitutes the Spacial court? Who designates the Spacial court? For what purpose the Spacial court is designated or established? So who does it and the purpose? Section 435 says that the central government may, by notification in the official gazette, may establish or may designate as many special courts as it thinks proper. Why? For the speedy trial of the offences. Which offences? Which are punishable for imprisonment not less than 2 years or more than 2 years. So establishes central government may, by notification, the official gazette may establish or may designate as many special courts as it thinks proper for the speedy trial of the offences punishable for 3 years or more than 3 years. Then the Special court will consist only a single judge. Single judge. Who will be qualified? Who will be qualified? Or who was immediately before the appointment at the Special court? Immediately before it, he was holding the office of session court or additional session court. Now what do you mean by designate? Designate only means that the central government may designate the session court as the Special court or may establish for the speedy trial. Punishment 2 years or more than 2 years. Single judge who was holding office immediately before the appointment as the session judge or the additional session judge. Section 436. The Special court can try other offences as well. So section 436 widens the area of section 435. 436 says कि suppose some case has been referred to the Metropolitan Magistrate or Judicial Magistrate first class, and Judicial Magistrate has detain that man for a period not exceeding 15 days, he is the judicial magistrate. Or executive magistrate has detained the person not exceeding 7 days. And these magistrates feel 7 days for executive magistrate and not exceeding 15 days for judicial magistrate. And these magistrates have the reason to believe that the detention is unnecessary. Then they may refer the case to the special court. A special court will take cognizance of it and will exercise the same powers as the judicial magistrate was exercising. This is another case which can go to the special court. Third, if suppose some person is accused of an offence punishable for not more than 3 years, and the special court feels that the speedy trial can be done, because the special court is established for the speedy trial. A speedy trial can be done. So a person is accused of an offence for a period not exceeding 3 years, and the special court feels that the summary trial should be done of this man. But if the summary trial is done of this man of an offence punishable not more than 3 years, then the special court will not punish him. In the case of the summary trial, will not punish him for more than 1 year. So therefore the special court, there is some case before the special court. The special court is going for the summary trial. Summary trial can be done only of a case which is not punishable for more than 3 years. And when the summary trial results in conviction, it should not result in more than 1 year, because it's a summary trial. But there the special court feels that the person is needed to be punished for more period, not more than 1 year. He should be punished for more than 1 year. Then the special court, after hearing the parties, may record the order and may hear or rehear the parties again, because till now you have heard in the summary trial, but now you feel he needs to be punished for more than 1 year. So you can hear, you can record the order, you can hear or hear the witnesses which you have already heard. So first is for a speedy trial. Second is you refer the case to the magistrate, detention, but he feels that the detention is unnecessary, refer to the special court. And the third, summary trial, but the punishment will not be for more than 1 year. And he feels that it should be more than 1 year, then go for not for the summary trial. Then beside this, if the offence is punishable under the Companies Act for not more than, for 2 years, more than 2 years, then together with this offence, trial of the offence, other offences can also be tried by the special court. This is 436. 437. As the High Court has the jurisdiction over the Session Court, because special court is a new concept. As the High Court has the jurisdiction over the Session Court, the same jurisdiction will be exercised by the High Court over the Special Court. Section 437. 438. The provisions of CRPC, as they apply to the Session Court, they will also apply to the Special Court. Then 439. So 435 you will establish. 436 the offences which can be tried by the Special Court. 437 High Court will have the jurisdiction over the Special Court as it has over the Session Court, and 438 CRPC will apply. 439. All offences are non-cognizable except the offence under section 212 subsection 6 of the Companies Act 2013. All offences are not cognizable, non-cognizable except the one, it is cognizable under section 212 of subsection 6 of the Companies Act 2013. What is that offence? That offence is only of fraud under section 447. So that is cognizable. Otherwise all offences are not cognizable. Then how the court will take cognizance of such offences? The court will not take cognizance of offences committed by the company or committed by the officer of the company unless the complaint in writing is made either by the shareholder or by the person authorized by the central government or by the shareholder. So court will not take cognizance of the offence. Committed by whom? Committed by the company or committed by officer of the company. Unless the complaint in writing is made. Made by whom? By the shareholder of the company or by the registrar or by any person authorized by the central government. If the registrar or any person authorized by the central government makes a complaint and then you take cognizance, then they will not be required to be present personally in the court of law unless the court especially asks them to be. So this is one part. So how the court will take cognizance? Complaint and writing, then you will take cognizance. If the complaint is made by the person authorized by the central government or by the registrar, they will not be required to be personally present unless the court especially asks them to be personally present. Then further, secondly, but there is offences in regard to SEBI. If the offence is in regard to transfer of shares, issue of shares, non-payment of dividend, then the court may take cognizance on the complaint of a person authorized by the SEBI. And such provision will not apply if the complaint is made by the company against its officers. And similarly, this section will not apply if the liquidator files a case in the case of the liquidation. So this is 439. Section 442, because we are talking about the speedy trial, therefore a new concept has been given. What is that concept? Mediation and the conciliation panel. Central government has been given the power to maintain the conciliation mediation panel consisting of the experts with such qualifications as may prescribe. Why it is constituted? Why it is maintained? It is maintained, and for which purpose? So central government shall maintain the conciliation, the mediation panel consisting of the expert with such knowledge as may prescribe for the proceedings which are pending before the central government, before the tribunal, or before the appellate tribunal. So therefore remember here, proceedings are already pending before the central government or the tribunal or the appellate tribunal. You maintain the conciliation, the mediation panel. Then what any of the parties to the proceedings says to the central government or to the tribunal or to the appellate tribunal, as the case may be, kindly refer our case to the mediation and the conciliation panel. So case is pending, you have established, you have maintained, any of the parties request to refer our case to the conciliation mediation panel. Then the central government or the tribunal or the appellate tribunal, as the case may be, may refer to the mediation and the conciliation panel. Not actually refer. The central government or the tribunal, the appellate tribunal will appoint any of the experts from that panel to whom the case will be referred. So case is already pending, you request, and then they may appoint one of the expert as the person to whom they will refer. And that person will follow the procedure as may prescribe and will dispose of within 3 months from the date of making the reference. So section 435 is Special Code, 436 is Special Code will take cognizance, 437 jurisdiction, 438 CRPC will apply, 439 all offences are non-cognizable except 212 subsection 6, which is about the fraud of section 447, and the court will take cognizance. How the court will take cognizance, that we have seen in section 439 and section 442, conciliation and mediation act panel. Then the same chapter of the Special Court, the company prosecutor is appointed. The government may permit to make appeal against the acquittal if the acquittal has been done by any court other than High Court. Then the government may ask for the filing of an appeal. This all. Thank you. Thank you so much.